All right, let's proceed further. I have a friend named Lily, and she's a fashion designer. She wants to start her own business of manufacturing garments. So she has approached us, chartered accountants, for advice. Now she is confused. She doesn't know what kind of organization is suitable for her business. So we, as chartered accountants, have to advise her. So we ask her a few questions. Okay, Lily, do you want to do business alone as a proprietor? She said, alone means I'll have to manage everything. We say, yes, you'll have to manage everything. Or else you can also do business in partnership. But you will need to ask your friends or anyone who has the same idea as us. You can do business only with like-minded people. Okay, only like-minded people can come together for business as partners. She said, yes, I'll call my friends and ask whether they are interested in doing business with me. So she called 3 of her friends. Okay, she called her friends and she asked whether they would be interested in doing business with her. They said, yes, of course, why not? This is a very good opportunity for us. So Lily said that let's meet over lunch. Okay. So she said, yeah, they fixed a date and they all planned to meet for lunch and discuss the business idea. So Lily approached her friends and Lily also invited us because she wanted us to explain the characteristics of different forms of organization so that she can help, she can decide which kind of organization is suitable for the business. So we, as chartered accountants, are now going to advise her. All right. So we tell Lily and her friends that, see, there are 3 forms of organizations in which you can do business. Now, why are we studying all this? We need to study the Companies Act 2013, corporate law. We are studying something in the form of a story. My dear students, before studying the Companies Act 2013, we need to be convinced whether the company form of business is the right kind of organization. So in case we want to advise, we want to advise our clients, so we need to be first convinced what are the characteristics of a company. We should be able to compare and tell them that, see, these are the characteristics, and we should also be able to convince them whether company is a suitable form of organization or not. So after this example, we will conclude that yes, company has many advantages over the other forms of business. So stay patient. Now, you need not write all this in your notebook. It is just for discussion. So we sit with the friends, Lily and her friends, and we discuss and we advise them on the characteristics of these 3 types of organizations. So we start by discussing about a proprietor. Okay, so I have listed a few pointers and we are going to discuss on the basis of those points. In case of a proprietary business, tell me students, minimum number of members required are, we need just 1 member, ma'am. And what about maximum? Maximum also 1. So in case of a proprietary business, the single person is the whole and soul of that business. So he should be a very capable person in case he wants to run the business on his own. Okay, what about partnership? See, partnership requires minimum 2 members and we can have maximum 50. Now, this maximum limit was never given in the Partnership Act. It was always given in the Companies Act. This was given under section 464 of the Companies Act, that in case of an association, if the number of persons exceeds 50, then it needs to be incorporated as a company, failing which it would be considered as an illegal association having no standing in the eyes of law. So if you are an association carrying on profitable business, then in case the number of members exceeds 50, you need to immediately register yourself as a company. Otherwise, you will be considered as an illegal association. So we can have maximum 50 partners in a profit-making partnership business. If it is exceeding 50, you need to immediately convert your partnership into a company. Okay, if I talk about private company, all right. Now, she doesn't want to do business alone. So OPC is out of the question. And traditionally, all the provisions were made keeping in mind the only 2 kinds of company, private and public. Even today, the provisions applicable to private company automatically apply to OPC. So basic classification is always private and public company. So let's talk about a public company. All right. In case of a private company, minimum 2 members, maximum we can have 200. In case of a public company, we need minimum 7 members and maximum, there's no limit, unlimited. Okay, there's no limit. So I think this is a very good form of organization if you want to raise more capital, because there is no limit to the amount of capital that can be raised in case of a public company. There is no limit on the number of members. All right. But there are only these 4 friends, na? They can't start a public company because they need minimum 7. So we'll have to advise them accordingly. All right. What about a capital contribution? How much can you raise in a proprietary business? It's very low. It's low. What about partnership? Yeah, medium. How much money will these 50 people bring, right? So the amount of money that we can raise is medium. What about a company? Yeah, company can raise a high amount of money because there are 200 members in a private company. There is no limit in case of a public company. So yes, they can raise a lot of capital to run the business. What is this capital known as? Just for our knowledge. This is known as proprietor's capital. Okay. In case of partnership, it's known as partner's capital. And in case of company, it is known as share capital. Now let us discuss something about share capital. We are advising them to start a business. So we'll tell them that, see, you'll have to contribute money. So they have decided that each of us will contribute rupees 1 lakh. Okay. Now they have all contributed rupees 4 lakh. This is known as capital. Okay, this is capital. Capital is the aggregate amount. Now, Lily wants to know that out of this 4 lakh, how much is her money? What is her share? So we tell her that, see, out of the 4 lakhs, you have a share of 1 lakh. Okay, that is your share. Hissa bolte hain na Hindi mein. So each of them has a share of 1 lakh. Not a share doesn't mean the value of a share. Share means their part in that capital. Okay. Now, when I divide this capital into the smallest unit, that is known as a share. That is why it is called as share capital. So what is the meaning of share capital? Exactly, it means what is my share in the capital of the company, and the smallest unit into which it is broken down is known as share. Okay. The share capital is actually a word which shows aggregate. It shows the total amount. But if I want to talk about the smallest unit, then I call it only share. I don't use the word capital because capital always shows me aggregate. So what is my share? What is the smallest unit into which it is divided? That is share. So yes, then we will discuss later on that each share has a face value. Okay, that is a value of per share. So that will determine the amount of money that you are bringing in. What are the shares that you will get? So that we will study later. So they want to know what is their share in the capital of the company. All right. So that is their share capital. What are these owners known as? They are known as proprietor here. In case of a proprietor, they are known as a proprietor. In case of partnership, they are known as partners. And in case of a company, they are known as shareholders. Okay. Now, I explained that what is your share in the capital of the company. Now, the smallest unit is known as a share, and the person who holds it is known as a shareholder. So, see, these terms, they all make a lot of sense. They are known as shareholders. What about the liability in case of a proprietary business? Liability is unlimited. It means that there is always a fear of losing your personal property. There's no limit to the amount of money that you need to put in the business, because in case there is no money in the business, your personal assets will be liable. So there is always a fear of losing our personal asset because there's no distinction between the business and the businessman. My liability is unlimited. It is not limited to my capital contribution. In case of partnership business, it is joint, several, and unlimited. Joint means we are jointly liable. Severally, we are liable not only for our share but also for share of others. And yes, there is no limit to the amount of liability. It is unlimited. So I am liable jointly, okay, individually, but I am also liable together, severally. So I am liable not only for my share but also for the share of others. So if he is not able to pay, I will have to pay. So and also over here, the liability is unlimited, it means my personal assets are also liable. In case of company, this is the best feature. I'll write it in red because it's the best feature. The liability is limited. It may be limited by share, or it may be limited by guarantee. Limited by shares means, let us discuss over here. So let's say that each of them has contributed rupees 1 lakh. Let's say that the value per share is 10 rupees. That is the face value per share. So they will each get 10,000 shares of face value 10. Okay, so 1 lakh. Now, face value, it means this is the maximum amount per share that they will be responsible for, that they will be liable for. Now, let's say out of this face value of 10, they have paid 6 rupees. So, what is their liability per share? It's only 4 rupees. This is their liability. But can I tell them, no, the business doesn't have money. Why are you paying only 4 rupees? Give us 6 rupees instead. No. You can now claim only 4 rupees. That is the balance. Okay. This is their liability. The balance of rupees 4 is the liability. Okay. So we have already received 6 rupees. We can call only 4 rupees from them. Total, we can ask for only 10 rupees per share because their liability is limited. We cannot tell them to give more. This amount can be called up anytime during the lifetime or at the time of winding up of the company. But what is the meaning of company wherein your liability is limited by guarantee? Now over here, liability limited by guarantee means the amount that these members have promised to contribute at the time of winding up of the company. So how much are you going to contribute? So Mr. X says I will contribute 1 lakh. Y says I will contribute 2 lakhs. Z says I will contribute 50,000. We are telling them pakka, guaranteed. Na? They are saying yes, we will contribute that much money. The amount of money which they contribute, which they promise to contribute at the time of winding up defines a company limited by guarantee. But yes, there are many other options also that company may be company limited by guarantee may have share capital, may not. I know you know more than what I'm discussing right now, but please keep all that on hold. We will discuss all that slowly. So yes, you can have company limited by guarantee. What about separate legal entity? There's no separate legal entity over here. No, there's no separate legal entity. There is no distinction between business and businessman. All right. So we are liable for the acts of the business. Business is liable for the personal acts of that proprietor. Here also there is no separate legal status. There's no distinction between business and businessman. Partnership and partners. But yes, this is the best feature of a company separate legal identity. In CA Foundation, we had discussed a case law, Salomon versus Salomon and Company. Yes. So business is different from the businessman. Business is different from the person who has formed the business. This means that I cannot hold the company liable for act of the members. Members are not liable for acts of the company. So the company is not liable for acts of members. Members are not liable for acts of the company. There's a distinction between both. The assets and liabilities of the company belong to the company only, not the members. What about the management? Who manages a proprietary business? He himself will have to manage. So we are telling Lily, see, if you are ready to manage everything on your own, then you can start a proprietary business. So yes, the management is by the proprietor himself. Who manages a partnership business? The partners only manage it. So it is managed by the partners. What about a company? Board of directors. It means, okay, board of directors. It means that the members need not worry about management. See, it is possible that there are like 4 members in my friends, Lily and her friends. There are just 4 members. They may become the directors of the company. It is possible that members are also the directors. They are members, but they are managing the company. But it is not compulsory. The members need not worry about management. They can appoint professionals to manage the company, and they are known as board of directors. The professionals are known as board of directors. So yes, you need not worry about management of the company. What about the business document? What kind of document will you enter with yourself? Na? So in case of proprietary business, there's no document. So there is no documentation. In case of partnership, yes, we may have a partnership deed. It may be in writing or it is oral, but there is some agreement, there is some deed. We may have entered into some kind of a small agreement, wherein we discuss about profit sharing, remuneration, etc. In case of company form of business, yes, of course, we have all perfect documentation in place. So we have the memorandum of association and articles of association. The memorandum actually defines the scope of power of the company. Scope means what is the company authorized to do. So it determines the scope of power. Company क्या काम कर सकती है. Okay. So what is the company authorized to do? So I'll write it over here. What? What is discussed in the memorandum and how it is to be done. What is the procedure? What are the rules? What are the regulations that is given in the article? So articles basically are the internal rules and regulations of the company. Basically the procedures, how that work is to be done. See, I have the power to borrow, but are there any restrictions and how it is to be done? That is mentioned in the articles. So these two documents are compulsory. Without these two documents, you cannot incorporate a company. Is there any effect of death or insolvency on these type of businesses? In case of proprietary business, yes, it comes to an end. Unless, of course, through inheritance, your son is managing or somebody else is managing. But yes, it ends. And it is affected. In case of partnership, of course, there is dissolution. It may be of the partnership or it may be of the firm. In case of death, there may be dissolution of partnership, there may be dissolution of the firm. So in case, let's say there are only two partners, one partner dies, the firm dissolves. So insanity, insolvency, in death, these are all grounds for dissolution. What about company? Company is not affected by death, insolvency, insanity of members. The company is separate and distinct from the members who have formed it. There is no effect on this. Okay, no effect. Members may come, members may go, but the company continues till it is wound up. This is nothing but perpetual succession. Yes or no? Yes. So death, insolvency, insanity of members does not affect the continuance of the business. Since it is brought into existence by operation of law, it comes to an end also by operation of law. It doesn't die a natural death. It's not affected by the insolvency, insanity of the members. I think this is a very good feature of a company. Now let us try to conclude something. So now my friends want a conclusion. They have understood all the features of these three types of organizations. Now we need to conclude whether the company form of business or a partnership is suitable for them. So we are trying to highlight the best features. Okay. Now in case of company, there is no limit on the number of members, and even then in case of private company, the members can go up to 200. The amount that can be raised from them is very high. The liability is limited as compared to the other forms of business, which is again a wonderful feature for any kind of business organization. There is separate legal entity. You need not worry about management. It can be managed by board of directors who are professionals in managing the company and the business. There is proper documentation. So in case of dispute, we can always refer these documents. Plus, these documents make the business more organized, structured. There's no effect on death, insolvency, insanity of members. So the business can continue till it is wound up. So I think from all, as if we compare all these three organizations, company form of organization outshines all. I think it is one of the best. There's only one drawback which I always feel in case of a company is that there is a lot of filing, documentation, audit needs to be done. There are certain expenses which you have to incur. So there is a lot of compliance. Okay, there is a lot of compliance which you need to follow. There's no flexibility. Those are a few downsides of a company. That is what I feel. And I think most of the people who are doing business in case of company will agree with that. That there is a lot of documentation, there are a lot of compliances, there is a lot of filing, there are many expenses which you need to incur because you're a company. But then there are so many other benefits also as compared to the other form of business. So then I think my friend Lily is now convinced that company form of business is suitable for her kind of business. All right, so I think we were able to convince her, and through this we are also convinced, before we study that, we should also be convinced that yes, there are many advantages of doing business in a company. I'll give you my personal example. When I started my business of these online lectures, so I had an option of either going in for partnership or a company form of business. I also had an option of LLP, but I don't know, I chose a company form of business because whenever you tell any person that I am running a company, automatically in their mind they will start thinking it's an organized structured form of business with all the compliances in place. You go to any bank or you go to any foreign client, they will trust a company more than other forms of businesses. Why? Because every document is now available on the website of MCA. If they want they can download any document. So there is a lot of transparency, there is a lot of trust as far as a company is concerned. Even one of my friends was telling that he's in the business of software. So he said that whenever I approach a foreign client and I tell them that I'm a company form of business, they start trusting me more. They immediately feel that I will be a more organized form of business. So that is the impression which we can give to our creditors or to our customers in case we incorporate a company. Okay, so I think I'm now totally convinced that a company form of business is a good way of running our business. Have you ever wondered what is the meaning of the word company? Have you wondered? Do you know? The word company is actually made by joining two different words. Okay, it is again based on two Latin words, com and pani. Okay, so the word com means with or together, and the word pani means bread. Bread? Are we in some cooking class? No. Bread. Now, when my friend Lily wanted to discuss business with her friends, what did she tell them? Let's meet for lunch and I'll discuss my business idea with you. Yes? So this is what would happen in the leisurely past also. Why am I using the word leisurely past? Because that time the size of business was small and people had a lot of time to discuss these things. So in the leisurely past, businessmen would take advantage of social gathering. They would meet together, like if it's a small town, so there's a festival like a mela. Okay, there is a festival, and all these business community or businessmen would come and discuss business over a meal. That gave rise to the concept of a company. So company means to come together and to discuss business over a meal. Okay, it's a meal. Now, even today, whenever we want to discuss anything with our friend, or you want to discuss any business idea, you call your friend, let's meet for a cup of coffee, I need to discuss something with you. So even today, discussions do happen over a meal. But in today's form of big organizations, like you cannot expect a company like Reliance to call all its customers and say, let's discuss business over a meal. It's not possible, no? So very slowly, because of expansion and growth of the business, the size of business has increased. It's not always possible to discuss business over a meal. But yes, the origin of the concept was when people come together and discuss business over a meal. That is known as company. Okay, so coming together is known as a company. Now, if I want to simplify this, okay, if I want to give you an equation, I will say that company is nothing but an association of person. Okay, so I'll just write it over here, association of persons. It means when people, like-minded people, okay, they come together, it's an association of person. There is also one more term which you will be studying in tax. Body of individuals. BOI. Body of individuals. Now, what is the difference between these two? The word person over here includes natural person. It means a living person, someone who takes birth. It also includes an artificial person. Okay, the word person, just a minute. The word person includes both natural as well as artificial. Artificial is nothing but your body corporate, yes? Natural and artificial both are included here. But in case of a body of individuals, we include only natural persons. Okay, natural. Individual means someone who's living. So only natural can form a body of individuals. But association of persons can be formed by natural or artificial, or maybe a combination of natural and artificial persons. So even a company can incorporate another company. All right, I'll just erase this. This is no longer relevant for my discussion. So is every association of person a company? No. When these people come together having a common object in mind, okay, having common object, only then it is known as a company, or you can also say it is a body corporate. Now there's a difference between company and body corporate. This is also a body corporate. Company is a body corporate, but every body corporate is not a company. We'll be discussing that in the next video when we discuss the definitions. I'll explain the difference between company and body corporate. Now, so association of persons having some common object, when they come together, then it forms a company. Tell me, Lily and her friends, they have come together with some common object in mind of manufacturing garments. Can they say, I am a company, I need all the benefits of the company or the privileges of a company? Does anybody know that you have been, you are calling yourself as a company? Can you yourself say that I'm a company, I want all the privileges? Law says that now that you are coming into an organized structure of business, there is one more procedure. You need to register yourself with the registrar of companies. Okay, so we need to also register. Okay, where will we register? We will register the business with ROC. Okay, so an association of persons having common object, when it gets itself registered, then yes, you can say that this is a company. Okay, this now forms a company. So what is a company? It's an association of persons, just a moment, having common object, when registered becomes a company. So now you can say that the company is formed or it is incorporated by the operation of law. It comes into existence by the operation of law through this method. Through registration, you are incorporating, you are bringing the company into existence. All right, students. So this was something about company. You want to write this? You can pause the video anytime you want. All right. Now, let us proceed. I will require your textbook now. As I mentioned earlier, your textbook should always be with you while watching the lectures. So I'll need the textbook now. Okay, let us start reading. Let us start highlighting the important words, terms, the keywords, so that it helps us in the exam. Ma'am, will they ask all this? Like, will they really ask why was this act introduced? What is the preamble? I don't think they will ask you, but if you're studying the act, you need to know some basics. Later, I'm also going to show you the Bare Act, how are the sections arranged, what are rules, etc. We're going to see all that. So it is going to be very interesting and very practical actually. Now, our first chapter is a preliminary chapter wherein we will study section 1 and section 2. Section 1, it gives the short title, the extent, commencement and application. Section 2 is basically the definitions, okay? So that we are going to study subsequently. So in preliminary chapter, we are going to study section 1 and section 2, okay? Now, we are studying the Companies Act 2013. Why 2013? We had 1956 acts in so many years and everything was going properly. Why was it amended to 2013? What was the need for that? Now, consider the year 1956, and you consider the time when this act was introduced, 2013. There was a major change in the economic and other and international environment of the company of the world. Businesses, the meaning of businesses had changed completely by the time we entered the 2000s. Now, earlier the business were limited to a local boundary, maybe national boundary. They never crossed the national boundaries. The exports were limited. Now because of internet, there is no limit to or there is no boundary within which you need to function. Your businesses have now gone global. Like, people who are living in another part of the world can watch your videos on YouTube. You can earn through YouTube. It is a good source of income. Like, even these lectures can be purchased from by people not only from India but from other countries as well, wherein they have similar laws. So there is no boundary. The business has gone global. Accordingly, the accounting has also become global. Now, if you are going global, if your accounting is now as per the IFRS, before you do all that, you need to change law. So law also needs to be global as per the international laws. That is why we felt the need to bring the Companies Act 2013 and replace the 1956 Act. Earlier, if you see the 1956 Act, all the sections were scattered. Like, if you wanted to incorporate a company, you were never very sure as to the sections which were applicable. Now, if you see the arrangement of sections in the chapter, all the sections related to incorporation are under one chapter, and the sections are properly numbered in a sequence. Even the forms, earlier they had form numbers. We could never make out the provision to which this form related. But now if you see the numbering, it is alphanumeric. So MGT relates to management, SH relates to shareholder. So it is so easy for us to know the provision to which it relates to just by looking at the form number. The penalty is very important. The penalties, like earlier in the act, there were like 100 rupees penalty, 10,000 rupees. What is the value of 10,000 rupees nowadays? So people were not scared only because they were like, how much is the fine? 10,000, pay 10,000 and go against the act, no problem. Now the fines have increased. Some places it's lakhs, even crores of rupees. There is imprisonment also. So there are so many reasons which required which we felt the need for amendment in that act. And yes, 2013 act was a welcome move, but there was a lot of confusion for many years because there were so many amendments. Even today there are constant amendments which take place in the Companies Act, and it's now a part of learning. So even we have got used to it. Every year, every attempt, we have so many amendments that need to be discussed and taken care of. Okay, so yes, there was a need for a new Companies Act, and this was because of the change in the national and international economic environment. So we'll now highlight the important words. The changes in the existing company law were indispensable. Indispensable, you can write the meaning. It means unavoidable. They were inevitable. It was bound to happen. It was unavoidable. It had to happen. Why? Due to change, we will highlight the word change. Due to change in the national and international economic environment. So these are our keywords. I'll teach you how you need to memorize these keywords and how it will help us during revision time. Okay, so it was indispensable due to changes in the national and international economic environment. It was also required for the expansion and growth of our economy. Okay, so there are two main points which we have studied here. There was change in the national and international economic environment, and it was also required for due to the expansion and growth of it. It was due to, and it was also required for the expansion and growth of our economy. So many changes were made, keeping companies, exports into mind. The Companies Act. Now, what is the aim of Companies Act? It aims to, you can highlight, improve corporate governance. Now, what is the meaning of corporate governance? Corporate governance means the manner in which a company is governed or managed. We are going to study about this in accounts of company. So, to improve corporate governance means the manner in which company is governed or managed. The aim of 2013 Act has always been transparency. So they want to ensure that there is a lot of transparency. Transparency means that the members are aware of the activities of the company. So in order to encourage that, through corporate governance, we have asked the companies to make a lot of disclosures, like you need to form various committees. Okay, you need to inform the members as to the number of board meetings that were held in the company. When was the annual general meeting held? What are the different committees? What is the code of conduct? Are there independent directors in the company? So there was a lot of disclosure which was required, and yes, these things were implemented for better governance or for better management of the company. So in this manner, we have tried to ensure that the company is managed in the best interest of the members. It has aimed to simplify regulations. I don't think they have managed to do that. There's a lot of confusion. But yes, it strengthens the interest of minority shareholders. Now, who are minority investors or minority shareholders? I have 5 shares of Infosys. It's not significant at all. I have only 5 shares. There's nothing to be happy about. I have 5 shares of Infosys. Out of the so many shares, I have only 5 shares. I'm a minority investor. Nobody consults me before taking the decision. Most of the decisions are taken by the majority shareholders. So these minority shareholders, the minority investors, they were all upset. So in the Companies Act 2013, we have mentioned that no, there are certain decisions in which you need to take the approval of these minority investors also. But this has unfortunately given rise to green mailing. Green mailing, ma'am, we had heard of blackmailing. What is the meaning of green mailing? Green mailing means that these minority investors know that things can't proceed without their approval. So they say that give us something and we'll give you our approval. So that possibility is always there. It has tried to legislate the role of whistleblowers. Now, who are whistleblowers? This is a word which finds its origin in the English law. In England, the policeman, he would blow his whistle loudly to attract the attention of the passerbyers in case he saw some offense being committed on the road. So let's say that he saw that a person was, trying to steal the purse of a lady, and lady was not aware, she was busy talking or looking at something. So he would blow his whistle loudly to attract the attention of passerbyers. See, something is happening over there. Stop that person. I'm coming. In the same manner, if you see something wrong happening in the company, like that the board of directors, they are committing some fraud, or there is some higher person in the management who is trying to siphon off money from the company, you can try and highlight that fact to the higher authorities or even SEBI. Now you can do it anonymously or you can reveal your name. But if you reveal your name, there is always a possibility that the person will be demoted, or he will be ridiculed in the office, or we will tell them he is not one of our own. See, he is a person who always likes to complain, and you are not somebody who is with us. You want to go against us. So we may ridicule him. Arey, don't do something in front of him. He'll go and complain. So earlier there were no rules protecting the whistleblowers. But now under section 177 of the Companies Act, we have proper rules wherein certain companies need to also have whistleblowing policy. How will you try to protect the interest of whistleblowers? They cannot be demoted, their salary cannot be reduced, they cannot be removed from the organization. They need to be protected, their interest has to be protected. So what are the steps that you are taking to protect the whistleblowers? All that is listed in section 177 of the Companies Act. So yes, this was a very positive move by the Companies Act 2013. They have tried to legislate the role of whistleblowers. Thus, it has made our corporate regulations more contemporary, more modern, more relatable. Okay, it has made our regulations more contemporary or modern. Then we have what is the preamble or the long title of the act. See, preamble is actually, I'll write a mnemonic for you. It is some easy way to remember. SOP. So what is the scope, object, and purpose of the act? What is the meaning of long title? Long title actually describes the act in detail. But in case of Companies Act, the preamble and long title are the same. Okay. Now let's read and try to understand what is the scope, object, and purpose of the act. See, if you read the sentence, you will understand that this act is an act to consolidate. Okay, this is the purpose, to consolidate and to amend, yes, to change the law relating to companies. This is my keyword. Okay, this is the pink highlighter which I had asked you to keep with yourself. So yellow, pink, and green, I want these 3 highlighters when we study law. So it is to consolidate and amend the law relating to companies. It has given us so much clarity that this act is only for companies. It is for consolidating and amending the law relating to companies only. Actually, listen, I have a proprietary business. Will the Companies Act apply to me? No, it is very clearly mentioned in the preamble. It is very clearly mentioned in the long title of the act. It applies to companies only. Okay, I have a partnership, last doubt. Partnership, no, it is applicable to company. It is so very clearly given in the long title. Okay, so this is an act to consolidate and amend the law relating to companies. So the preamble and long title are the same in case of Companies Act. Short title is given later, that this act will be known as the Companies Act 2013. Okay, so that is how you will describe in short. This is the Companies Act 2013. All right, so long title is slightly elaborate. Enactment, yes. This enactment, the Companies Act received the assent or the consent of the Honorable President on 29th August 2013. Yes, do you remember in the previous part of this lecture, we had discussed how does a bill become an act? It becomes an act only and only when it receives the approval of the president. Acts always require approval of the president. Yes, we cannot say that for law, but to become an act, you need the approval of the president. That was why it is because of this I had explained how an act comes into force. So it receives the assent of the president. Now, Mr. President knows that there is some new act which has come into force. Do the public know about it? No, so make a public announcement. So we will notify it in the official gazette. Official gazette is a booklet which is published on weekly basis by the government of India. Earlier it was even published in print. Okay, it was printed by the press of India, the government press. But after COVID, everything changed, and now you have everything in the soft copy. Just visit the website of this official gazette, and you can find archives of all the announcements which were made. See, in case of any public announcement, the official gazette looks something like this. See over here, the Gazette of India. Can you see this? So this is how these public announcements are made. If you see how the amendments are made, okay, if you see the amendment as how it is released by the authority, so it will be on this head, that is the Gazette of India, and then they will mention the amendment that is in two languages, mentioned in two languages, English and Hindi. So yes, this is the Gazette of India. This is how the announcement is made in the official gazette. It's a booklet which is published on a weekly basis by the government of India, and all the archives are also available online. It was notified in the official gazette on 30th August 2013. So the act actually comes into force on 30th August, the day on which it was notified in the official gazette. Students, we can write over here that I have left space also. Section 1, which we are going to study next. Section 1, it was notified immediately. Okay, it was notified immediately on 30th August 2013. Okay, it was notified immediately. But there were other sections which came into force on various other dates. Like section 2, it came into force on 12th of September 2013. Okay, so like this, 98 sections. Are they going to ask all this in the exam? No. So don't worry. 98 sections were notified on 12th September 2013, and 183 sections were notified on 1st April 2014. So they came into force from 1st April 2014, and so on. Okay, and so on. So because I'll write that also, I think, and so on. So if you read over here, it was notified in the official gazette on 30th August. However, different dates may be appointed for enforcement of different provisions through notifications. So only section 1 came into force immediately, and then slowly the sections were notified. All right. Arrangement of sections. The sections are arranged into chapters. We will go through the bare act in some time. Now, just like your textbook, okay, the entire syllabus is broken down into small chapters, and those chapters contain various sections. Okay, so we have the act, which is divided into chapters. The chapters are divided into sections. The act is divided into 29 chapters. Okay, so we have 29 chapters, and each chapter has a certain set of sections. So we will be studying next. I'm not explaining here. Like, first chapter is the preliminary chapter. Second chapter is incorporation and matters incidental thereto. Third chapter is your prospectus and allotment. So the textbook also contains the index according to the chapters as how it is given in the Bare Act. Now we are going to study total of 148 sections, but yes, in the new syllabus, they have increased the number of sections, so the notes will be amended accordingly. Each chapter has at least one set of rules. Now, what are rules? See, the act is made by the parliament. Okay, the act is made by the parliament. But the parliament has given the central government the power to make certain rules for carrying out the provisions of this act. Okay, I repeat myself. The parliament has given the central government the power to make rules for carrying out the provisions of the act. Okay, rules for carrying out provisions of the act. This is given under section 469 of Companies Act. You don't have this in your syllabus, but it's just for your knowledge. Okay, it is given under section 469 of the Companies Act. I'll just highlight this. So each chapter will have at least one set of rules. Now, what are these rules? See, when the parliament, it comes up with the act, it says that, let's say for example, the definition given under section 2 clause 85 of a small company. So how is a small company defined? Small company means it's a private company. The paid up capital does not exceed 50 lakhs or a higher number as may be prescribed. Where is it prescribed? It is prescribed in the rules. So sometimes while making the act, the parliament is not ready with the nitty-gritties, or they are not ready with the numbers, they are not ready with the rules that should apply, or the provisions that should apply to that particular concept. So they say that for the time being we are enforcing the section, but later on the central government has been given the power to make certain rules for carrying out the provisions of the act. So we say that a form needs to be filed with ROC, but what is the form number? All that will be mentioned in the rule. So sometimes it is given in the section, but sometimes then they are not ready. They will always say as prescribed. And where is it prescribed? In the rule. So you have to refer not only the act but also the rule. But don't worry, your notes are made in a format that it covers both section as well as rules. I have given everything in a proper answer format. Okay. So yes, it will have one set of rules. So every chapter will have a set of rules also. There are 7 schedules. These schedules are supporting the act. Now, these schedules basically contain the formats. Like, I want to know how to make a memorandum of association. I have no idea. So you can refer the model memorandum and articles of association that is given in Schedule 1. Schedule 3 will give you the format in which you need to prepare the balance sheet and profit and loss account. Schedule 7 will give you the list of activities which are considered as CSR. So basically these schedules, they give extra information which we could not give in the act. They also specify the formats. They support the act. They don't override it. Okay. What is the definition of a company? Very important, because we are studying the Companies Act. We need to know the definition along with the section number. So section 2 clause 20. Section 2 clause 20. You need to remember this. Section 2 clause 20 of the Companies Act defines a company as. Company means a company which is incorporated under this act. Okay, this act or any previous company law. So say for example 1956, 1913 and so on. Now my company was incorporated after the 2013 act. So yes, the act applies to me. But Reliance was incorporated in the year 1973. Will the Companies Act apply? Yes, of course, because the word company over here includes all the companies, whether incorporated under this act or any other previous law. You cannot say that no, that law was more convenient for me, it was more favorable. Hello, if we are using the word company, it includes every company, whether incorporated under the 2013 act or any act prior to this. So even if the company was incorporated prior to the 2013 act, this act will apply. All right. Now, what are the features of a company? See, company is an incorporated association. What is the meaning of incorporation? So when an association, okay, I'm starting with the word association. When an association of persons having common objects, they are registered with ROC, then that is nothing but incorporation, and that is how a body corporate or a company comes into existence. Okay, I'll just write company because we are discussing company. So what is company? Company is an incorporated association. Why incorporated? Because company is not a living person. It is an artificial person. So I'll underline artificial person. It is an artificial person because it doesn't take birth like a natural person. It has to be brought into existence by operation of law. It is created by law. Yes, because it is not a living person. It doesn't take birth like a natural person. It has to be formed, incorporated through the act of law, okay, by operation of law. But it has separate legal status. Yes, we have studied this. It has separate legal status. Perpetual succession. Members may come, members may go, but the company continues till it is wound up. It is not affected by death, insolvency, insanity of members. It has a common seal, but if any, because after the 2015 amendment, okay, after the amendment in 2015, affixing of common seal is not mandatory. It's not compulsory. Why? Do you know the reason why? I'll tell you. Now, in earlier times, the kings, monarchs, they were not well educated, or they were not educated at all. Why? Because they were always busy learning the art of war. Like, take for example, Akbar. He was a great king, but he could not read and write because from a very early age, he was sent on the war front. So he was trained to fight a war, and he was not trained in learning or, going to school, etc. So because these kings, they were not educated, they could not sign the documents. So what they would do, they would just print their ring, okay? They would just put an impression of their ring on the paper, and that was considered as the seal. Okay, so they would just press their finger ring on the paper, and that was considered to be a seal and signature of the king. Nowadays, in case of a company, see, since it is a separate person in the eyes of law, company is capable of contracting. If the company is contracting, it needs to have its own signature. But company is an artificial person. How will it sign? So earlier we would say that common seal is nothing but the signature of the company. But now, people who manage the company, the directors, company secretary, they are all very well educated. They can sign on behalf of the company. So now we say that common seal is considered as a relic of medieval times. It is reminding us of medieval times when people didn't know how to read and write. Now, since everybody can write, they can sign the documents. Let's make it optional. Okay. So common seal is now optional. But yes, your articles may specify that the company would like the seal on these few documents. That can be mentioned in your articles, but it is not compulsory. It is not mandatory. If you are not affixing the common seal, then that document will be signed either by 2 directors or 1 director and a company secretary if you have a company secretary. So it is not compulsory. So students, with this, we come to an end of the introduction. Now, ma'am, we have written so many things actually. How will we revise all this? It's very easy. And you won't believe how easy it is to revise the entire table in just 2 minutes. I'll show you how. Okay, why was the Companies Act introduced? It was indispensable because of the change in the national economic environment, and also because of the growth and development of the economy. Why was this act introduced? It was to consolidate and amend the law relating to companies. See, we have highlighted those terms. To consolidate and amend the law relating to companies. It received the assent on 29th August. Section 1 was notified. It received the assent on 29th August. It was notified in the official gazette on 30th August. Section 1 was enforced immediately on 30th August. 98 sections, they were notified from 12th September. 183 sections were notified from 1st April. There are 29 chapters in this act. Each chapter has one set of rules. There are 7 schedules. What is a company? Company means an means a company incorporated under this act or any other previous company law. What are the features of a company? It's an incorporated association. It's an artificial person created by law, perpetual succession, separate legal entity, common seal. These are the keywords. These are the points that we need to remember. All right. So students, this was the introduction. Okay. This was the introduction of the Companies Act 2013. In my next video, I will discuss section 1 and we will also discuss the definitions. I will also show you how to remember all the section numbers. Okay, I will show you how to remember all these clauses. I already have made notes for you. So I'll show you how to remember those clauses in a story format. So watch out for the next video.